Afternoon, everybody. Welcome to the second day of Hermes training. Today there will be two sessions as a routine, and we have two distinguished guests, Donald Taylor and Stephanie Kruger. They will make their presentations, and I would like to thank both Stephanie and Donald for their valuable contribution to the Hermes project as an instructor, and my special thanks goes to Donald, because it's very early in the morning in Canada. Thank you for joining us today, Donald, as instructor. We are so excited to follow you, and the microphone is yours. You can start your presentation.
Thank you very much.
I'm going to turn off my microphone and
there we go. So again, good morning, good afternoon, everybody. As Eric Guru said, my name is Donald Taylor, and I work at Simon Fraser University, which is in the city of Vancouver in Canada. And there I am, the university's copyright officer, and I also supervise interlibrary loans. So today I'm just going to talk briefly to you all about copyright in general and the licensing and how it interacts with interlibrary loans. So what is copyright? Copyright protects, as you can see on the slide here, literary works, dramatic works, musical works, and many other things, including things you may not normally think about, such as television broadcasts, a lecture in a lecture theater, okay, a dance. So whether you are scanning a chapter for a library patron or sending a journal article to another library, you're going to encounter copyright protected works when you do resource sharing work. So copyright refers to the right to copy a work, of course, but also other rights, such as the right to, as I said earlier, to broadcast or to publish or to translate, and do many other things. And it also includes the right to allow others to do these things. So only the copyright owner can do these things, except in specific circumstances, which would be outlined in a country's Copyright Act. The copyright owner is usually the creator of the work, such as the author, but copyright can also be transferred. For example, it can be transferred to a publisher. And in that case, it is the publisher who owns the copyright in the work and not the original author. So copyright protection is effective immediately and automatically when a work is created. You don't have to register it. You don't have to do anything special. It automatically exists. It doesn't last forever. It will expire one day. The general rule for the length of copyright protection varies between countries, but in many countries, it is either 50 years after the death of the creator or 70 years after the death of the creator. And finally, copyright law is national. Each country has its own Copyright Act, and that act governs copyright in the country. So for example, if you are working in Turkey, you are going to apply Turkey's Copyright Act to any copyright protected work. It doesn't matter where the author is from or where the publication is from, you would use Turkey's Copyright Act. Copyright serves a specific, well, it serves a few different functions. One of the main purposes is to allow the creators of works to benefit economically and socially from the effort they put into creating new work. Copyright law also serves the public interest by allowing users to do certain limited things with copyright works without asking permission. So this can include copying a certain amount of a work. And what this does is these limited exceptions encourage further research and creativity. And of course, resource sharing is one of those public interest things that libraries do, and that exceptions are there to encourage. Copyright, of course, is important to resource sharing because resource sharing frequently requires that we make a copy of something to fulfill a request. And as we learned, copying is an exclusive right under copyright. So copying something for interlibrary loan or for resource sharing, document delivery, that engages copyright. Also, as we'll learn later, many of our digital resources are governed by a license, and in those licenses, sometimes publishers will try to limit the ability of a library to use resource sharing with that digital resource. Now, just for a little bit of history around copyright, there's common agreement that the first true copyright legislation was the Statute of Anne, which was passed in England in the year 1710. And that legislation provided copyright protection to a work for 28 years after publication. And as you can see, the length of copyright protection has increased significantly since that time. And of course, as you can see, after England had their copyright law, many other countries, of course, produced their copyright laws. And just a reminder again that copyright is national. So it's always each country's law is what applies in their country. So again, copyright in each country is governed by national legislation. However, because of this national treatment, this meant that in the 18th and 19th centuries, countries gave little or no copyright protection. So for example, France did not protect works by British authors, and Britain didn't protect works by French authors. And there's a little illustration here from 1886 from the British journal Puck. And it shows how the Berne Convention was going to bring an end to the practice of not respecting copyright. So this idea of not respecting foreign copyright all changed in 1886 when the Berne Convention, or more officially, the Berne Convention for the Protection of Literary and Artistic Works, was adopted. So the Berne Convention's core principle is national treatment. And what that means is that each country that has signed the convention agrees to treat the nationals and citizens of other countries the same as they treat their own. Also, the Berne Convention has been incorporated into international trade treaties as it's part of the World Trade Organization's Agreement on Trade-Related Aspects of Intellectual Property Rights, or TRIPS agreement for short. As I said earlier, copyright it expires, but there is a term of protection. The length of protection differs by country, as we've said, but in general, the same things are protected in every country. But the question is, what makes something protected by copyright? Well, there's a few things, as you can see on the slide. One, the work has to contain some level of creativity or originality. Not very much, very, very little creativity, but there has to be a little bit. The work has to be in what's called a tangible or a fixed form. So copyright doesn't protect ideas or thoughts. It only protects them in a fixed form. And a tangible form would include, say, a photograph on your smartphone, a file that you have saved to the hard drive on a computer, notes on a piece of paper. That's a fixed form. Finally, not everything can be protected by copyright, and facts and data are not protected. They are not protected by copyright because they just are, okay? There should not be any creativity for example, in data. A good example of data is rainfall data or temperature data. So the rainfall data for the city of Vancouver is a fact and it cannot be copyright protected. Anybody can use it. And remember again, copyright is automatic, no need to register the work. As I said earlier, there are exceptions to copyright's exclusive rights. Copyright is only a temporary monopoly, it's not permanent. So most copyright legislation has exceptions that allow for users to copy a certain amount of a work for a specific purpose. And also, there may be specific exceptions for certain groups. There might be exceptions specifically for libraries or for educational institutions or for individuals for personal use. And there's also normally a general exception that applies to everybody that can be used by anyone. And that general exception is called fair dealing in countries such as India or Kenya. It's called fair use in the United States and some other countries. Yet in other countries, it's called the right of quotation, or in Turkey, it goes under the name of reproduction for educational or information purposes. And as I said earlier, some countries have library-specific ones. For example, in Canada, we have a specific exception for resource sharing. So that general exception that can be applied almost in every country in the world, there are basic guidelines that you have to ensure that you follow when you apply that general exception. So that fair dealing or right of quotation. So here you can see them on the screen. First one is the work should be used for non-commercial purposes such as education or research. The amount copied should be minimal, like one chapter, one journal article. Consider the type of the work being copied. And lastly, give some consideration to what effect the copying would have on the market for the work. So is copying the work or part of the work going to lead to a reduction in sales or otherwise act as a substitute for the work? So next, I'd like to touch briefly on the public domain. And the public domain does not mean works that are in the public. When it comes to copyright, instead, the public domain means those works where copyright has expired or those works that were created with no copyright protection. So works that were never protected by copyright can include data and facts, as mentioned earlier, such as rainfall data or geographical distances. Also, simple expressions of data, such as a very basic table or a chart or a basic graph, are also not protected by copyright. They're in the public domain. In some countries, government documents or legislation or court decisions are not protected by copyright. Other countries like Lebanon, what are called folkloric works, are considered to be in the public domain. And also, of course, the copyright holder or the creator can choose to release their work into the public domain. The public domain also includes works in which copyright has expired. As we said earlier, each country has its own public domain since copyright is national. They have different terms of protection. You see some of them listed here on the slide. Also, different types of works get different protection. For example, in some countries, photographs have a different term of protection than, say, a book. Okay. So that means that every country has a different public domain. It depends on the country you are in. And of course, so it's important for future creativity to have many things in the public domain so that we can build upon older works to create new works. So they become free for us to use. So once something is in the public domain, it is free to use. Anybody can use it for anything they want to use it without any restriction. An important exception and copyright law for libraries and for many other people as well are exceptions for people with perceptual disabilities. So there is now an international treaty for people with perceptual disabilities. It's called the Marrakesh Treaty, and it came into force in 2013. So this treaty recognized the barriers that are faced by the visually impaired, and it encourages the creation of works in accessible formats. So there's now this international legal framework. Many countries have adopted this into their copyright law. And for libraries, one of the important things about the Marrakesh Treaty is that it allows a library to create an accessible work for a library patron in another country. So it encourages international resource sharing for patrons who are blind or have other perceptual disabilities. So how does copyright interact even more with resource sharing than what we've discussed so far? As we know, it's certainly the resource sharing and copyright are closely linked, but it's different for copies or for physical materials. When you lend physical materials to another library, it normally falls outside the scope of copyright law, since most countries have something called exhaustion, which means that once a work is sold, the copyright holder cannot control subsequent distribution. That means that if you buy a book, you are free to give that book to somebody else. You can sell that book again. Okay, you can do whatever you want with it in terms of like giving it to other people to use. Just like when a library owns a book, they can choose to circulate it. They can choose to send it to another library, etc. However, when it comes to sending a copy to another library, that's an entirely different thing, because in that case, you're making a copy, and making a copy engages copyright. Consequently, you have to make use of one of your Copyright Act's exceptions in order to provide a copy to another library. Many countries have exceptions that explicitly allow for document delivery between libraries, while in other countries, the library has to depend on that general exception. Therefore, it's necessary for people working in resource sharing to know the rules in their national copyright legislation that allows them to make and send copies to other libraries. So the copyright responsibilities of the staff in the borrowing library are going to be different from those in the lending library. So the staff in the borrowing library are requesting the material, they are receiving it, and then giving it to their patrons. Whereas the staff at the lending library are copying and supplying material from their library's collection and sending it to the other library. So the borrowing library staff, they should make sure to abide by any of the relevant copyright exceptions in their Copyright Act. They should observe national guidelines and rules for placing and fulfilling requests. The borrowing library should include a statement that notifies their patron that the material should be used for educational, research, or personal purposes. And finally, the library that borrows the material, when they deliver it to their patron, they should do so in a way that makes it a little bit difficult, at least, for the patron to redistribute it, okay? So, you could give it to the patron in paper format, or you could use a secure cloud service, that's password protected. Okay, so something that, limits the ability to redistribute the work to others. So the lending library, the library that is providing the material, they should include a copyright compliance statement, to the borrowing library that states that the document is to be used in compliance with the local copyright law. Don't use documents that are obtained from shadow libraries. So don't go to Sci-Hub and use it to fulfill your requests. We'll talk about Sci-Hub later. Once you've filled requests, don't save those scanned copies and use them to fill later requests. You should always be making new copies each time you fill a request. And finally, track requests that you've fulfilled so that you can pay any required copyright royalties if in your country you do have to pay copyright royalties. So staying with this idea of making copies, there is an emerging method of making print materials available in digital format called controlled digital lending. And what that does is, it's very new, it's not very widespread at all, but it is something that's there and it's only going to grow. So it involves making print materials available in digital format and circulating that digital book using digital rights management to prevent further copying, to control its loan period, and to prevent redistribution. A library makes a digital copy of a paper book and circulates the digital book in place of the paper book. And if they do that, they have to follow some very strict guidelines. First of all, they would remove the print book from circulation and only circulate the digital copy. You need to only circulate the same number of books that you purchased. And you may be wondering, what's the legal understanding for controlled digital lending? So there's two legal principles that support controlled digital lending. One is that exhaustion doctrine we already talked about. The other one is technological neutrality, which is a feature in many copyright acts that states that copyright should be applied equally to all mediums and formats. So that would allow you to make a copy of the print work as long as you didn't use the print work, but you used the new digital work. So controlled digital lending, when it is usually used when a paperwork is not commercially available and when no digital version for libraries is available. Now, as I said at the start, we also wanted to address licensing. Licensing content is different from owning content. So libraries have been commercially licensing digital content since the 1990s, so over 30 years. And many libraries now pay more money in licensing fees than they spend on acquiring physical content. Commercially licensed content is governed by a license. So when a library owns a physical item, it's governed by copyright laws. When you license content, it's governed by the license. So that's a big difference. And of course, the rules can be different for each digital resource because each resource comes with a different license. So licensing content, it has consequences for the ability to provide standard library services such as resource sharing. Why? Because many library practices are based on the library owning the material that it lends or from which it is making a copy. But libraries don't usually own the electronic books and the electronic journals and the databases that are in their collection. Instead, they lease them, they rent them. And the use of the resource is governed by a license. And the license sets out how the library can share the digital content via resource sharing, how library patrons can use the content, how it can be accessed, and many other things. So even though digital resources have been used in libraries for 3 decades, most library users and library staff are not aware that the use of digital resources is governed in a fundamentally different way than a physical item. So what's a license? A license is a contract, and it's between a vendor and a library. And a contract allows the vendor or the copyright holder to use private law to control the use of the material rather than having to be constrained by your country's copyright law. Licenses often contain provisions that restrict how much and for what purposes content can be copied. For example, they might allow copying by a student for research, but they won't allow copying for resource sharing purposes. As well, resources can come with technological protection measures that prevent making copies, or it only allows you to make a small amount of a copy. So what are the contract terms, or how do the contracts work? An important part of a contract is that a contract is only valid when both parties agree to them. Okay? It's not a contract unless you both agree to it. Therefore, it's important for librarians to try to negotiate better terms in the licenses that they agree to. So for example, if resource sharing is covered by your National Copyright Act, you may want to try and include a clause that states that nothing in the license can override your country's Copyright Act. Or you may want to at least ensure that the license allows for some limited form of resource sharing. So resource sharing is fundamental to libraries, and therefore librarians should do their best to ensure that licenses for electronic resources allow for resource sharing and document delivery of that digital resource. In some countries, librarians don't have to worry about this because their country has contract override legislation. So the United Kingdom, Singapore, Ireland, they all have laws that do not allow a contract to override a copyright exception. So in these countries, those parts of a license that would restrict the exercise of copyright restrictions are not enforceable. As well, library associations in many countries are recommending contract override legislation in their country. And IFLA has a helpful document on contract override called Protecting Exceptions Against Contract Override. And you can find that on the internet. So you might be wondering, how is a license enforced? So either party to a license can enforce it if the other party does not fulfill their responsibilities. A classic example of this is, say one of your patrons downloads too much material too quickly from a database. In that case, the vendor will often suspend the license and suspend access to the database for a short period of time until the library agrees to correct the situation. So every contract comes with the ability to suspend or end it if the other party doesn't do what they're supposed to do. Finally, just want to touch upon the question of, can a license really override copyright legislation? And if you ask a lawyer, the lawyer will say yes, licenses override copyright legislation. You may see in some places legal scholars saying that, oh, maybe contracts can't override copyright legislation. However, this is just academic speculation. So we should always assume that a license overrides copyright legislation until your country's court or legislature says otherwise. So and as a consequence, it is incumbent upon resource sharing departments to follow, as best as they can, the resource sharing provisions in licenses for digital resources. And just wrapping up here, just want to touch very briefly on the topic of shadow libraries. As you all have heard through this presentation, only the copyright holder can authorize a license to be applied to their work. Therefore, large collections of copyright protected works that are made available without the copyright holder's authorization cannot be considered openly licensed or free to use. So what this means is that if you collect a bunch of thousands and millions of copyright protected works and go ahead and just put them up there on the internet and make them freely available to anybody, that is copyright infringement. And that is what shadow libraries do. The best example of a shadow library is Sci-Hub. So since a shadow library, like Sci-Hub, does not have a license to make available others' copyright protected content, they are infringing copyright. And as such, resource sharing departments must not use shadow libraries as a source of filling requests. So as you can see, copyright and licensing is a topic that will continue to impact libraries, and thus it is an important subject for librarians. Understanding the basics of copyright will help libraries to fulfill their public service mission, particularly resource sharing, and it will enable librarians to reflect on the wider impact of copyright so that they can engage with civil society in their country on the issue of copyright reform when the opportunity arises. So thank you very much for your attention this afternoon for you, morning for me. And if there are any questions, I am happy to answer them.
Donald, thank you so much for your detailed presentation. Actually, it was very international, and I'm sure that it will be very useful for interlibrary loan librarians, and we will reuse again and again your presentation on our YouTube channel after uploading it. Also, your survey is ready. If you want, we can conduct it to the audience. It depends on you. If you want, we can do it.
Yes,
right
please.
now.
Yeah, let's send out the evaluation questions.
Okay, okay. Ramazan, can you please conduct the survey?
Yes, of course, today.
And there are some comments about your presentations, and many of them are
Ahmed is saying he has a question. Maybe we'll give him. Yes.
Can you follow the question on chat box? You can read and answer, Donald.
So Ahmed's question is, do you think the copyright term should be indefinite even though the creator is dead? And is it okay for artists, musicians, etc., to resurrect outdated works in the age of technology? So as I said throughout the presentation, copyright, it does expire. So personally, I don't think it should be indefinite. I think there should be a limited term to it, as most countries have. So yes, I like the idea of a limited term of copyright protection. So many years after the death of the creator. And of course, so the next part of the question is it okay for artists and musicians to resurrect outdated works in the age of technology? Yes, I mean, as long as it is done legally. So if the work is in the public domain, by all means, resurrect it, reuse it, put it to new use, or if it's still being protected by copyright, ensure that you get protection first of all. But the whole purpose of the public domain, and one of the main purposes of creating work, is so that others can not just enjoy it, but so that it can be used as the basis for new works and new creativity, because, all of us, everything we do is almost always based on work that has come before. Okay, so as the saying is, we stand on the shoulders of giants. Okay, we're not responsible for everything we do. We're always building upon what others have done before us.
Can I add on this for the question of Ahmed? Yeah, so for the music industry, you have to make sure that the music, the words are protected and the music is protected. So the composer has rights on his music, and the one who wrote the words has other rights. So you have to make sure that both are in the public domain, the music and the words, the lyrics. I have a question if no one has a question or something about libraries, especially about licensing. So Donald, as you were saying, that a contract is between two parties, but in my opinion, the dominating party is the publisher. Libraries are like, for example, a publisher can, when he say, I don't want to renew this contract, it will be harming the library so much, okay? Because a big chunk of the collection will be removed from the library. So the library is in the weak position, and the contracts are signed every year. So every year they can change the terms, they can change the amount of money paid. What do you think can be done to make it a more equal relation? For example, signing a contract for 5 years, for example, with a stable amount of money paid in 5 years, or making it, or the content will be owned by the library after a certain period, for example. So what do you think about this?
So yes, so with licensing digital resources, as in many cases with contracts, there's a stronger party and a weaker party. Usually the stronger party is the one who is selling the content, and the weaker party is the one who's renting it or leasing it. So yes, libraries are usually in a weaker position. There's certainly, yeah, like you said, there's ways that we can try to get stronger. One thing is to, as you said, to try to maybe, negotiate longer terms. You have 5 years at a fixed rate. Libraries can get together and bargain as a group. So, lots of countries will have national consortia whereby, like all the university libraries in the country go get together and they operate as a large consortia. So they have both, lots of bargaining power. So they can, negotiate better prices and negotiate better terms. And of course, the more people that are involved, you can also pool resources so that, say you do get a license that allows you to truly own the material after a certain period of time, then you've also got the resources so that you can take the material from the publisher and host it locally on your servers and make it accessible. And it's much easier for 20 libraries to do that than for a single library. And actually, when libraries group together to, particularly as a region, to negotiate with a publisher, it also serves the vanity of the publisher too, because if a publisher can say, all the libraries in Canada have purchased our resource, that makes them look really good, okay? So even though Canada might be smaller than California, it still looks impressive to say that a country, has purchased your stuff. So yes, working together always makes you stronger. So that's the way to do it, I think.
Thank you, Donald, for all your answers. Also, still the survey is open for the answers. I think we had several submissions for the survey. It will be available in few more minutes also. And we are going to analyze the results at the beginning of next session. If there is no more question, we can finish your session, Donald. It seems that there is no question on chat box. Thank you for your informative and detailed presentation one more time. And thank you for your time, of course.
And thank you very much. And thank you all for your attention this afternoon.
We will be here in 15 minutes, means 3 o'clock by Turkish local time. Now we have a short break before the next session. See you in 3 here. Bye-bye.
Bye, everybody.